In the 2011 Lobbying Disclosure Act disclosure database for the spend on lobbying dollars around the America Invents Act, which was the last large change to the U.S. patent system, the Lobbying Disclosure Act database of spend on lobbying dollars around just that statute was $1 billion.
Hello, I'm Bruce Berman, the host of Understanding IP Matters, a podcast series that looks at the impact of intellectual property rights on people and business. Season 3 spotlights such topics as artificial intelligence, IP licensing, and TikTok as a learning tool. Enjoy the episode. Once the world's gold standard for encouraging innovation, the U.S. patent system is fast losing its leadership position. That is what many believe. Despite the myriad of technology developments and businesses the system has spawned over the past 40 years, patent reliability today is highly uncertain, and licensing inventions is incredibly difficult. And don't think China hasn't noticed. If the U.S. has an innovation policy, now is the time to rethink it. But what should it look like? Our guest today will attempt to provide a clearer picture. Dan Brown is an award-winning designer, inventor, and entrepreneur, having founded Loggerhead Tools. Dan has received over 100 U.S. international utility patents, 10 international design awards. He is also a professor in the Siegel Design Institute at Northwestern University. Dan was elected to the National Academy of Inventors and appointed to the Patent Public Advisory Committee for a 3-year term by the U.S. Secretary of Commerce. F. Scott Keefe is a member of the faculty at George Washington University Law School. From 2013 to 2017, he served as a commissioner of the U.S. International Trade Commission, which enforces acts of unfair competition, including IP infringement. Scott was the senior fellow at Stanford University's Hoover Institution, where he researched commercializing innovation. Scott practiced as both a trial lawyer and a patent attorney and has served as an advisor on national security and economics to high-level government offices, including the Bush, Obama, and Trump presidential administrations. Before attending law school, he studied molecular biology and microeconomics at MIT. Welcome, gentlemen. I think you have more in common than just a love for innovation. You're both Chicago area exponents, I believe. Is that true, Dan?
I'm a Southside Irish kid, yeah.
And Scott?
Yeah, I grew up on the South Side, 18 years in Hyde Park. My folks taught at the University of Chicago, and we lived on campus.
Did you know that before you met?
No, didn't know that at all.
It's a small world.
It is a small world.
Today, I'd like to talk a little bit about U.S. innovation and what can be done to encourage it. Since the adoption of the American Invents Act in 2011, patents have become increasingly unreliable, especially tech patents. The courts, too, have become less receptive to IP holders. How did we get here, and what can be done to improve the situation? Scott, let's start with you.
It's a real pleasure to talk with you, Bruce, and you, Dan, and we're all working together here to help folks get a sense of where we've been and where we are and where we're going. What's interesting about the U.S. patent system is that it's gone in cycles, and both the political left and the political right in the U.S. have been part of each phase of the cycle. So we've had cycles where both Democrats and Republicans are very skeptical of predictable enforcement of patents, and the opposite. For example, in the 1980s, you saw the single biggest domestic policy initiative of the Carter administration embraced by the incoming Reagan administration, which was to re-strengthen the patent system in the United States and to coordinate not only patent law, but also how we finance basic research and how we deliver products and services into our economy.
You're referring to Bayh-Dole and the Court of Appeals for the Federal Circuit, CAFC. Those are early 80s innovations, if you will.
Right. And they're innovations that were first pushed proudly by a Democratic administration and then implemented proudly by a Republican administration. This is one of these approaches to good government in our society that truly can be and has been bipartisan.
Dan, what's your take? How do we get here?
Yeah, I completely agree with Scott. There's no question. And what he's describing is what I often classify as that we have a very schizophrenic innovation policy system. Every election cycle, every politician cries for innovation to create jobs and benefits, et cetera. And then once they get in the office, they become prisoners of special interest groups that are raising money so they can get reelected. And that competition dynamic in the market, which we rely on to, sort out the winners and losers, is driven by those that have the gold, so to speak, and they get the policy they want. And this is a real problem for us because this is a very short-term Wall Street mentality, but innovation is a long-term strategy, the 5-year plan in China, et cetera. And there's just no way for us to balance a system where we claim and we hold inventors at a very high level, but then we do everything once they prove they have a competitive advantage.
Does the U.S. even have an overriding national innovation policy? There seems to be a lot of little policies coming out of NIH and other agencies, but doesn't seem to be.
I think rhetorically we do, but I think in practice we do not.
Dan's highlighting so many good points here. Maybe it can help us to unpack a few of them. One of the points he's highlighting is that innovation is about the future. And we all have famous quotes we can quote about the future, but the one thing we all know about it is that none of us knows the future. The other key insight Dan's highlighting is not only do we not know the future, the innovation ecosystem depends upon investing in the face of that risk in the long run. And then there's a third insight he's correctly highlighted, which is that the political economy machinery inside every economy, including our own, is the exact opposite. It's cannibalistic, it's schizophrenic, it's got the attention span of a gnat, and it's hooked on caffeine, and so it keeps shooting itself in the arm to juice itself up. In the 2011 Lobbying Disclosure Act disclosure database for the spend on lobbying dollars around the America Invents Act, which was the last large, and I think many of us feel very counterproductive change to the U.S. patent system, the Lobbying Disclosure Act database of spend on lobbying dollars around just that statute was $1 billion.
Now, who's doing that spending?
So a few things are worth noticing. First of all, in those days, that was a complete successful presidential election, $1 billion. These days, presidential election campaigns are a little more than that. But in 2011, that's all it took to become president of the United States. So when there's that much money rushing down K Street, and remember in 2011, that was after several years of a similar pour floodgate down K Street. So you ask who's paying for it, and the other side of the coin is who's receiving it. And as Dan's pointing out correctly, it is so seductive for political actors in Washington to notice that flow of cash. And that's campaign cash. That's above board, legally paid, legally received cash. So they do pay attention to it. And, who can spend that kind of money? Large established players. And large established players are not anti-innovation. They do innovation as well. But in the short-term attention span of today's headlines, today's clicks, today's votes, today's lobbying wins, you get these odd coalitions built up around a set of laws that are so unfortunately compromising for a truly diverse innovation ecosystem that the large established players end up, unfortunately, not only shooting themselves in the foot, but everyone else as well.
I think you're referring, Scott, to the FANGs, among others, the big tech companies. The irony is, and I think something very hard for people, even bright people to understand, investors in particular, is they have so many patents. They have tens of thousands of patents. How can they not like them? The disruptive nature of patents is what they fear.
To sort of color in the lines that I agree with Bruce completely on, but taking it from another perspective, I think the fundamental root of the problem is we have a moral hazard problem in this country around innovation and competition and fair competition, in the sense that everybody wants this investment to create the jobs and create the economic benefit. The reality is making money and the short-term drive to make money is efficient infringement. And this efficient infringement does not get punished, nor does not representing your elected duties to your constituents. It gets caught up in the mess. This moral hazard is so crazy in the sense that when the music industry and the entertainment industry was getting ripped off by technology that evolved in the years for mass production of electronic technology, they rushed to Congress and they lobbied, and they've got the willful infringement of their copyrights and trademarks. It became a criminal prosecution. It wasn't criminal before, but patents were not, because in the big ecosystem of making quick money, big companies would sooner steal and not pay a royalty or not buy it like this anymore. They can steal it, and the worst they get is a slap on the wrist of, if they ever get fined, it's possible treble damages. And there's just, they make more money than they lose, even if they get caught, and they very seldom get caught.
Well, it may be legal to do efficient infringement or have that strategy, but it's questionably ethical. If people understood, shareholders, stakeholders understood what they were doing, they may think differently. I think of it as diversity and inclusion. There's the eco-awareness, and then there's technology as well. But technology has never really been discussed in that context, though. Not yet.
So what I have, you brought that up, ecology, et cetera. Back in the 70s, they passed the Clean Air Act, and it was important because we were polluting like crazy everywhere. But there was no criminal liability there. And people found for years they can litigate, and they just fought, paid the fines, but they never cleaned up the air and the water. Until, I believe it was the Reagan administration, made it criminal to avoid this. And all of a sudden, a couple of people from the industry I was in went to jail. And I got to tell you, all of a sudden, they found the resources within industry to start cleaning up waterways and cleaning up the air. And we've seen a major advancement from that. Now, in Lake Erie, you go walleye fishing. Before, the Cuyahoga was so polluted, the organics, when it caught on fire, they let it burn to burn off the organics. But it's just that's the moral hazard. That's the situation that we're in. We do not have the efficient infringement and the stealing of people's rights. What it destroys in innovation and what we have for our society isn't felt by the people that are doing that.
Just to build on your conversation about patent counts as well, I agree with what's been said by both of you. One of the things to notice is the conversation has shifted in the United States discussion about patents from an inherently disciplined, tethered to reality discussion. It's shifted away from that to an unhinged, open textured discussion. And it's on purpose and not by accident. So what do I mean by that? In a normal competitor to competitor patent infringement setting, both sides of the dispute have totally selfish reasons to do that horrible thing, be reasonable in how they state their claim, to be self-disciplined. What's nice about that is reason and record drive the analysis. We can get it wrong. Judges get things wrong all the time. It's not perfect, but it is anchored in reason and the record. And here's why. If a patentee is charging an alleged infringer with infringement, the patentee has to conceptualize, argue over the scope of the patent claim. And on offense, the patentee's incentive is to blow up like a balloon that claim so it covers everything. But if the patentee on offense blows up the balloon that large that it in fact covers everything, on defense, it is a very vulnerable patent.
Patents issued, they're too broad very often, and they're under examination, under litigation, they don't hold up.
But so the whole point here is the patentee has selfish reasons to go for a middle road argument, and so does the infringer. If the infringer says, this patentee's claims are super narrow, therefore I don't infringe, the alleged infringer now has a hard time arguing the patent claim is invalid because it's so big it covers the prior art. That self-disciplining effect disappears in the world we're in now, and it's on purpose. In the world we're in now, a range of regulators, food and drug regulators, consumer safety regulators, privacy regulators, antitrust regulators, regulators of alphabet soup make their arguments against industry. And industry says back, we cry uncle, fine, we'll be regulated. But golly gee, dear regulator, won't you please allow us to keep operating in society, at least charging a little bit of money for profit? We're so impoverished. If you don't let us make money, how could we possibly pay our union workers a fair and honest wage? You have to let us earn some money. I have an idea. Let us charge based on how innovative we are. Oh, you want to measure how innovative we are? I have an idea. Let's count our patents. And they yell down to the team in the patent shop inside the company, and they say, I don't really care what those patents say. And I assure you, my regulator doesn't care what those patents say, because this is not a patent expert. This is a food and drug expert or some other expert.
I think God is really nailed the point. And I think at this point, since we're talking about innovation, we have to first acknowledge not all patents are innovative. My definition of innovation, this is what I did my research and thesis on. My definition of design is how humans seek, conceive, and create new knowledge. I see this as a knowledge rivalry, the existing knowledge versus the new knowledge. And innovation is how that new knowledge competes with that existing knowledge. And if we were to just take and give rights to those existing knowledge competitive advantages, we'd be fine. But we could blurt in all this stuff that Scott was just describing. It's people, it's asking the foxes to regulate the chicken coop for egg production. It's just crazy. It doesn't make any sense. But if there's a new product that enters the market and it's new knowledge and we can discern that factually with evidence, why do we not just say that innovation is going to be protected? But instead, if you're a small inventor, particularly, you have a competitive advantage. You bring it to market, you prove it works, it puts a target on your back. You're gonna copy you, and there's no downside. The moral hazard is there's really no downside to do that.
The U.S. tends to shy away from legislative policy. We're a free market country, and there's a lot of good regarding that. But can we let the markets decide with regard to technology who should be the winner and the losers, especially in view of China? Because China has a bottomless pit of capital to throw at things. And we don't even have policy. We're just allowing the big guys to battle it out and figure out who's best.
Well, I think Dan was on the right track there. I mean, I think the point is the future's hard. The good news is it's hard for everyone, including centralized autocratic governments in China and other parts of the world. And so, sure, they have a lot of control over their own people and their own economy. The good news is, despite that they've got a lot of control and a lot of money and a lot of power, the good news is when they make mistakes, they make a lot of them and they make them big. So, I think we're still going to be okay. I think our dominant strategy is to not try to pick favored industries, but it's to go back to the idea that Dan was describing, where you let coordination happen in a marketplace. Coordination is different than control. People like to tell the story of the inventive rabbit and the great wise social planner with a carrot, and you're going to get the rabbit to hop to the carrot. But that requires an immense amount of information. Did that rabbit eat a big breakfast? Is there a wolf standing in the room next to the carrot that the rabbit sees? These stories about patents as direct incentives to invent, I think, don't work very well. It's hard to get inside people's heads and figure out exactly the right measure of carrot to get them to hop to your command. And I don't know why you would want to get them to hop to your command, because why would you know any more about the future than the rest of us? But predictable property rights and patents can be something totally different. They can be a beacon in the dark. You put 1,000 people in a big theater, you turn out all the lights, you give one person a flashlight, and that person turns it on, and everyone in the room now knows exactly where that person is. Predictable property rights and patents can draw together, passively draw together, coordinate among the venture capitalists, the manufacturer, the marketer, the people with complementary skill sets, complementary technologies, and they can strike deals with each other. That coordinating, that bargaining, and that contracting, that is rule of law at its best. That is light touch government at its best. And that is using the knowledge in society as quickly as that knowledge arises without us having to reach into each other's heads and extract that knowledge.
Scott and Dan, what's going to take to get us back to where we were, say, 10 or more years ago, say before AI and various decisions which were adverse to patents?
I was an inventor. My first invention is 85, and patent rights were much stronger. We were able to enforce our patents. I've seen a lot of things go to market, make a lot of money, provide a lot of American jobs, et cetera. My product is made in the States. I tried to do it. It's impossible now, but I'm still dying trying. And the reality is it's a very complex and big problem. We have to get to a much smaller subset of it. So playing off this innovation, and if you read the PPAC last year, we focused on the inventor innovator, not just all inventors. So we have to get to the subset of inventors that innovate and make sure that their rights are protected. Because if their rights are protected, the rest of the rights will be, because they're not going to be threatened. No one knocks off a product that's not competitive. So if we're talking about innovation, we're looking at the competitive advantage of that invention. And the bottom line is we have to protect these inventor innovators. But what happens, well, the Google started out of Stanford with a great, more like this, a log algorithm. As they get bigger, they become very anti-free market and much more monopolistic. And they want to maintain that by using the weight and the power that they have. And the thing is, Bill Gates once said, I feared most was not, the big companies that are trying to get in their market. It's that guy in the garage or girl in the garage that's going to come up with the next new idea. And that fear causes them to act in this monopolistic behavior, and we have to stop it. And then you get into the retail markets where, you have situations where they do the, see no evil, say no evil type situation, and they'll sell knockoff products all day long, pretending that, they have no control of it, which is total BS. You can buy a bionic wrench off the internet and have it delivered to your place for less than I could sell it to a retailer for, made in the USA, and the shipping is subsidized by a thing called the UPU, which was an act created in the 1800s, where if I were to ship it, it's going to cost me $6 to $7 just to ship it. It's under $1 coming from China, and that's how you're getting all this stuff from China in the mail. And then the people selling it, who are part of the problem, just say, how are we going to control that? We can't do that. And it's BS, because if you took any of their intellectual property, if you started using their trademarks or whatever, they would be all over it in a second. It's just, they're making money on it.
Yeah, I agree. And I think that, first of all, we should not despair. Politically, socially, economically, I think we will get back to a better system. We have before, we will again. This more predictable approach to patents is something that the founders of the United States deliberately set up to distinguish us from what was going on in Britain at the time. We wrote our rules for our substantive patent law so that they weren't just prerogatives given by bureaucrats. They were tested based on the prior art and so forth. So our patent system was designed originally to be this way, and it'll become again this way. We have a lot of intellectual leadership on both sides of the aisle to support this approach. So philosophically, politically, we can get there. In addition, what do we do in the short term? Look, I think that there are tribunals inside the United States, like where I used to work at the U.S. International Trade Commission, and there are also tribunals outside of the United States, some of the Dutch courts, some of the British courts, some of the German courts, some of the Japanese and Korean tribunals. We have friends in the world who agree with these ideas, and we and they can work together with each other to support a diversified global value chain that supports domestic security, domestic economic growth, not in a way that is hegemonic, not in a way that is xenophobic, in a way that is authentically collaborative, but just also careful. And that approach in the short term will allow innovators to do market structuring and do transacting and do litigating. But it's much harder now than it needs to be. We can get back to a better system.
Scott, I've agreed with everything you said so far, but I don't agree with that. Maybe I'm too close to the fire and feeling the heat, but I don't have faith in these systems that lack accountability, which all these ones you described do. I've been involved as an expert witness in the ITC. I think the ITC is fine, but it suffers the same failures that we have at the Fed Circuit. The bottom line is that I don't think until we almost have a bit of a quiet, organized revolution in how we treat that inventor innovator and get a carve out for them to protect them because they are the seeds of the future. You're not going to stop this efficient infringement, and you're not going to stop the short-term games. I was knocked off on my product, 7-year legal battle. I didn't go to the PTAB because it was a little early for that, but I won willful infringement against both parties. It was so egregious. Now, you probably never heard willful infringement against two parties. We couldn't find it. Yet, when it came to getting the award, the judge throws the award out. It was just nuts. And the craziness is that there's so much politics and backroom deals and everything that goes on because of this ecosystem of favoritism and lobbying that the small inventor has no chance. We need a special protection around that small inventor innovator that stops this system from the cannibalistic nature. And we need to take those that are hell-bent on doing it, and we need to put them in jail because they are stealing.
I really want to support what you're saying in a couple of ways. One is, as a policy matter, where to go from here. I share your frustration and your desire to shift our system back and to get big changes soon. And I want to work with you and anyone else to get that done. So please don't hear me as anything other than enthusiastically supporting more of what you've said along that front. My suggestion about some of the specific tribunals is a second or third best. At least we don't have to kill ourselves. At least we don't have to hang our heads in total despair. I don't pretend it's sufficient to make us all satisfied from a policy perspective, nor do I want to claim that we are the inventors of any of this stuff, or that we're unique. But I do think that there are, for those in the immediate anxiety moment, what can we do right now in a specific case? There are some things that can be done where the cost of doing it is lower than the benefit, so at least it's rational to do it. But none of that is inconsistent with what you're saying, which as a policy matter, we should be, as a system, doing so much more.
So there is one thing. Bruce has heard me say this before, so you teed it up. I have to hit it. If we harmonize with trademarks and copyrights and make willful infringement, now that's not infringement that's accidental or whatever. Willful is a very, very high standard. Less than 1%, 2% of any cases that go to trial are found willful. It's very low. Make that criminally prosecutable. All we have to do, it's just like when I go back to that, what happened with the environmental acts, we start putting some of these pirates in jail, and all of a sudden they're worried about their skin and they'll change their behavior. Talking about the other systems, it's not a static situation, it's dynamic. And so while the ITC did a great job of stopping boatloads of stuff coming in because you can identify it through the shipping documents, et cetera, how are you going to do it when the stuff's coming in the mail and hundreds of thousands? It's not going to happen. I suffer that today. So while I think, okay, we have a system, we can oil it, we can move it, the pirates keep competing themselves and they keep getting better and they find ways to do it. We couldn't legislate and control alcohol. We can't control drugs, and we're not going to control this piracy. We have to control the people that are facilitating it. I was not knocked off by some strangers in China. I was knocked off by 2 American companies.
Scott, the ITC, it hears both international and domestic disputes regarding IP rights. What are the advantages of the ITC?
We're in a bad phase of our system right now. So I'm going to offer like a direct answer to your question because you've asked it. But please don't hear this as overstating the case. What I will just say is this. Big parts of modern policy debates focus on 3-letter government agencies inside Washington that are supposedly bipartisan. For example, the Securities and Exchange Commission, the Federal Trade Commission, the Federal Communications Commission. It's important to recognize those are all entities that were really set up as part of the New Deal. And it is not an accident that they are set up in one really important way that we should, unfortunately, we too often overlook. We should not overlook. They have an odd number of presidentially nominated, Senate confirmed leaders. You don't need to be a math wizard to recognize that what's special about an odd number is there is always a majority in one party. In addition, the president is given, in most respects, a fair amount of authority to appoint a chair to serve for many years and to remove the chair. Politically, what does that mean? It means you have a president backed up by a chair, backed up by a majority. So yes, those are parts of the US government that include people from both parties. No, that is not bipartisanship. That is a lot of juiced up power dressed up as bipartisanship. The ITC is a much older and deliberately different entity. It was created by the chairman of the economics department at Harvard at the time of the Civil War as a model in that person's academic writing. It was an economist named Frank Taussig, and Taussig structured a model agency that then became the Tariff Commission, which became the US ITC. And the model was radically different on purpose. 6 members. What's different is not +1. What's different between 6 and 5 that really matters is it's an even number. It is designed for deadlock. 9-year terms, staggered in the statute, with a statutory requirement that regardless of presidential inaction or action, the chair must rotate person and party every 2 years, regardless of everything else that's happening in DC. And therefore, even a majority of commissioners can overrule a chair over mundane garbage. You might think this is garbage, but you see these fights today. Even little things like the size of your office or the agenda for a meeting can be overruled by a simple majority. So what you've got is designed for deadlock. And what you get when things are designed for deadlock is hugely imperfect. And Dan is correct. It's becoming more politicized and less predictable, but it is still basically the best place in government to go to get a record of adjudication, where at least if you don't like the outcome of the adjudication, you can point out what is precisely in the record that is not being reflected in the ruling.
Yeah, it works for big companies, the big companies that were bringing things in, but for a small inventor to go to the ITC is still very expensive, and you don't get no financial award out of it. So then you can't get a pro bono attorney or attorney that's working on contingency. It's just not accessible to those inventor innovators. It works good when giant industries are battling on chips and all that kind of thing, but for those inventor innovators, we're talking about innovation, not working.
I'm delighted to, in a deeper dive in another setting, talk about both how to fix what Dan is pointing out, and even in the short term, how to mitigate those concerns for individuals, because they can be mitigated.
We're running low on time. Last question. What two things would you want to leave behind with the listeners with regard to the state of the IP system in the U.S.? What needs to be done? Dan, let's start with you.
Okay. Well, I'll get on my soapbox again. I think we could change things dramatically overnight by making it criminal prosecution for willful infringement. And it would go through the same system. We don't have to change anything in the legal precedents, none of that. We just harmonize with copyrights and with trademarks. And then to the ITC, and maybe even a broader category, that, we protect farmers and we protect important areas of our economy because they're necessary. Why don't we protect inventor innovators? Well, take a fund and say, okay, we gave you this patent. The patent is valid. No big company can look at that person and say, I can steal this and I can leave them bleeding on the street because they just can't afford to perfect their rights. Those are two things that we could do immediately, and it would not disrupt anything in a commerce that's going on, but it would totally change this efficient infringement mindset.
Well, is it better today or worse today than 10 years ago or 20 years ago?
It's worse. It's worse because of the PTAB and the way the patents are being lost. The big infringers get two bites at the apple. Unfortunately, at the PTAB, the challenges that have been instituted against the existing patents that went through the system, they lose at a far too high a rate, much higher than district court. The reality is that it's worse. It's far worse. And there's a lot of rhetoric and how we're going to address it. We have to start protecting these inventor innovators, or it's not going to change.
I really want to applaud what you each are bringing to this conversation. I want to encourage us all to do more individually and together and invite others into this as well. I think this is important. I also think it is scary sometimes to look out and say, boy, these are horrible settings. And I just don't even know where to start. I can't imagine what the toolkit would look like to solve this problem. And the good news I think we all should hold on to here is we do not have to invent these solutions. They are already invented. All that we have to do is convince our fellow citizens that it is in everyone's best interest to put down the bad tools and pick up the good tools. The tools already exist. How to make a predictable patent system, it does not require that we invent a new system. It merely requires we go back to what we have used before with very good effect, tools that are authentically supportable by a broad spectrum of Americans, regardless of identity or worldview. And so I'm an optimist, and I think that appealing to that sense of commonality, to that sense of history, and to the one thing that we know is an asset wherever people exist, and that is human brain power. And the way to unlock the leverage power of human brain power is with a rule of law, intellectual property protected system.
Well, thank you both very much. This was a fantastic discussion, and we'll have to have you both back on to continue it. Understanding IP Matters is brought to you by the Center for IP Understanding, an independent nonprofit Follow CIPU on LinkedIn at the Center for Intellectual Property. Content conveyed is for informational purposes only and does not represent the views of CIPU or its affiliates. This episode was produced by Jack Shields for Wild Creek Studios.